Hello, my name is David Ritter. I'm a partner with the law firm of Barnes & Thornburg. We have approximately 600 lawyers over 13 offices throughout this country. Many of our lawyers, almost 80 of them, practice in the area full-time of employment law. So there is very little, if anything, we don't do in the area of employment law. I have been happy to do these videos for the IMA from time to time. This, I believe, is the fourth one I've done, and I have done others in the area of terminating employees respectfully, non-compete law under Illinois statutes, and employee handbooks. So when deciding what to do this time, I was trying to think of what topic would keep employers up at night and what topics would they be very concerned about. And one sprang to mind immediately. It's Fair Labor Standards Act lawsuits. And why do I say that? Well, that'll come in just a moment. So wage and hour lawsuits are on the rise. It's simple. The first question is, why would that be? And the answer is simple. There is significant money to be made by plaintiffs' attorneys. When you have a single plaintiff case for discrimination, it's just one person. The damages for wage and hour lawsuits are much, much greater. You represent more than one plaintiff. They're usually class action. There's double damages, and the damages are not limited as they are in discrimination lawsuits. So that's another reason why they're on the rise. There's both federal and state laws that address this, and the federal and state governments are really focusing on this issue, which again makes it an area where plaintiffs' lawyers practice in a much greater demand and much more so than we're used to see. So, in terms of what can lead to a Fair Labor Standards Act lawsuit, we're familiar with exempt employees versus non-exempt employees. If you misclassify an employee, do not pay that employee overtime, and when they're entitled to it, everyone in that classification can get overtime. So again, it's another reason why the damages add up quickly and why plaintiffs' lawyers like them. Some employers require or permit employees to work what we call off the clock, before or after they've punched in or during breaks. And it's simple things, maybe running an errand, getting supplies on a truck, things of that nature. That's working time, and they need to be paid for that. So that's another type of lawsuit in this area. A lot of employers have bad record keeping. That can lead to lawsuits. The good news is that these are all things that an employer can fix and avoid. So that's something to keep in mind as well. And the plaintiffs and the Department of Labor are hard at work. In 2014, back wages collected by the Department of Labor were $240 million. In 2013, $250 million. The year before that, $280 million. Cases routinely settle for more than $1 million. Cases many times have more than 500 plaintiffs. And the number of these type of cases has increased for 7 straight years. They've jumped, believe it or not, 438% since the year 2000. In 2015, almost 9,000 cases were filed, and that's an increase from about 3,600 cases just in 2004. So, and one other point, this doesn't include cases filed under state law, which is very difficult to quantify and follow. These are just federal court lawsuits, so the number is actually quite a bit higher. So these are all reasons why it should keep employers up at night and why plaintiffs' lawyers go after this type of law. So this is something to pay attention to. So, but there's actually more. There's 2 hazards that lie ahead that I would actually like to discuss now. The first is proposed changes to the white-collar exemptions. So back in March of 2014, President Obama sent out a memo to his Secretary of Labor. And as part of this memo, he thinks that there are certain job classifications that should be required to receive overtime compensation and don't. And he told his Secretary of Labor to revise regulations to make this happen. You may have seen some of this in the news, both on the papers and on the TV news. And what happened as a result of that, in June 30th, 2015, the Secretary of Labor, Thomas Perez, for President Obama, issued proposed regulations. And we're going to go over them in just a second, but the staggering prediction from the Department of Labor is that roughly 1.2 to 1.3 billion with a B, billion, in additional wages will be paid through overtime to employees in the United States. So this is coming. We expect that these temporary proposed rules will become final rules sometime in 2016. So the time is now to know about these and to act on them. So what are these proposed regulations that are going to increase the amount of overtime pay? Well, there's a salary increase that it used to be $455 a week, that if you made below that, you would receive overtime. Now that more than doubles to $970 a week, or $50,440 per year. So employees who make less than $50,440 a year are eligible to receive overtime. So just stop for a second and think about that. Think about all of your first line managers and all of your supervisors that make less than $50,000 a year. You wouldn't think about paying them overtime. Now you have to think about that. And there's another change. There are some highly compensated employees, and that used to be $100,000. That's now raised to $122,000. So if someone made $100,000, you wouldn't ever have to think about paying them overtime. Now it's been raised to $122,000. So if someone makes $120,000, depending on other factors, they may actually be able to receive overtime, something else you need to think about. And what's more is, for the first time, the Department of Labor is going to have these numbers keep pace with inflation. So they will continue to go up each year. So not only do you have to think about what changes you need to make now, you are going to have to look at this every single year into the future. That's what these proposed rules are about. And rest assured, this is going to happen. This has a lot of support, and this will be implemented in 2016. The Department of Labor has said that this is, quote, a critical first step toward ensuring that hardworking Americans are compensated fairly and have a chance to get ahead. The rationale behind the rules is that if someone is not making enough money, we talked about $50,000, they either should be receiving overtime or they should be able to go home if they're only going to work 40 hours a week. But what the government has said is that it is unfair to make people making that amounts of money to work 50, 60 hours a week and not be paid overtime for that extra work over 40 hours, because we all know that overtime in Illinois kicks in over 40 hours in a work week. And the Department of Labor is estimating that approximately 4.6 million workers will become eligible for the first time for overtime pay as a result of this rule. 4.6 million workers. So let's talk about the white-collar exemptions for a moment, so you know a little bit of what we're talking about. There's several. There are executive employees, administrative employees, professional employees, outside sales employees, computer-related employees, and, as I mentioned before, highly compensated employees. Let's talk about them, for a moment. There's 3 tests that you have to meet before you get exempted from overtime compensation. The one is a salary level test, the second is a salary basis test, and the third is the job duties test. These are important because if you don't comply with them, the liability to you as an employer can be significant. So let's talk about these tests. In terms of the salary level test, that's what we talked about, that's going up. For example, on a yearly basis, it's going from about $24,000 to over $50,000. That's a significant jump, and you're going to have to deal with that, and we're going to talk about how to deal with that in just a moment. So if you're going to make less than $50,000, you're going to be eligible for overtime under the salary level test. Under the salary basis test, that's pretty easy. Does the employee regularly receive a salary, a predetermined amount of compensation each pay period? So that's pretty easy, and it's not based on the quality or the quantity of the work performed, because otherwise you'd be an hourly worker or a piece rate worker, and that's not what this is. You're a salaried employee. So, and then there's a job duties test, and I'm going to run through these for the different types of employees, because they do vary. For example, if you're an executive, your primary duty is management of the enterprise or a subdivision of it, and you regularly direct the work of 2 or more full-time employees, and you have the authority to hire and fire employees. So what you would think an executive would be. There's nothing tricky about that. We generally know who the executives are in an organization. The next one is in the administrative exemption. I will tell you right up front, I find this to be the most difficult one. The primary duty is a performance of office or non-manual work directly related to the management or general business operation of the employer or the employer's business, and the primary duty includes the exercise of discretion and independent judgment with respect to matters of significance. So that's the important part. The exercise of discretion and independent judgment with respect to matters of significance. So if you have a secretary, an administrative assistant, they're not going to qualify because virtually none of them are going to exercise discretion and independent judgment with respect to matters of significance. So that can be very much a gray area, and you're going to need to look at that closely to see if your employees meet this exemption under the job duties test. Professionals is another exemption, and that one is actually pretty easy. It's work that requires knowledge of an advanced type of science or learning customarily acquired by prolonged course of study. And let me give you some examples because that'll help. Doctors, nurses, lawyers, accountants, engineers, things of that nature. Those are under the professional exemption. Highly compensated, we talked about this. It used to be $100,000 and now it's going to be $122,000 adjusted upwards for inflation. Okay? And they also perform non-manual work, office work. So, what do you do? What do you need to do to plan for these changes? You're going to have many complicated issues as a result of these changes, and it's going to vary based on what your organization is like, how it's structured, and what your employee complement is. You should be considering these issues now because of the impact they will have on your budget, your operations, your staffing, and your resources. We expect that you're going to have very little time to go through this analysis once these regulations are issued. We believe it'll be 60, 90, 120 days before you're going to be required to comply with these regulations. So our advice, our strong advice, is that you get ready now. You should plan as much as possible, but don't make any final decisions until the final rule is announced. It is still possible things will change, and that may alter what you need to do, but you should have a pretty good game plan in place. You should seriously consider conducting an audit of all your job classifications. It's a really good time to see if the position meets the current duties test. Maybe you have some people that have been misqualified or misclassified, and they should be non-exempt when you've been classifying them as exempt. This is a good time to look at that. Are there currently exempt employees who earn less than the proposed new salary level? If that's the case, what are you going to do with them? Are you going to pay them more? Are you going to let them only work 40 hours a week? Are you going to hire more people to take up that extra work? Do you have employees in a single job classification who are both above and below the new salary level, which would mean some would be exempt and some would be non-exempt? That's not really a workable solution. Is it important to keep them all in the same classification, or can you keep them some exempt and some non-exempt? I wouldn't think so. You're going to need to make some decisions about that. Some other tough choices. Are you going to pay more employees to keep them exempt? If they're making $50,000 a year and they're going to be non-exempt, are you going to pay them an extra $500 to make them exempt? Okay, but remember, inflation, it's going to go up. You may have to keep giving them more money each year. But what if someone makes $40,000 and they were exempt before and now they're non-exempt? Are you going to pay them an extra $10,000 and you have a lot of people in that job classification? That becomes a much more difficult budgetary decision. You're going to need to look at that throughout your organization and see what makes sense given your employee complement. Should you just convert the employees from exempt to non-exempt? Okay, you can figure that out too. Does that make sense? Are you going to reduce their hours to minimize overtime costs? There's things you can do, but again, you got to think it through. Should you cut hours of existing employees and hire new ones? Hire part-time workers, lower the wages to cover a shortfall in hours, all possible solutions. What about benefits? Do exempt and non-exempt employees have different benefits? Do you need to look at that? Do you need to change that? You need to review your exempt workforce and identify those employees who earn less. You need to see if there should be a salary increase to maintain exempt status. You may have to look at implementing a new timekeeping system, having new job descriptions for people who are now have to punch a clock or keep hours that never had to do that before. Again, other things you're going to need to think about. Another thing that doesn't come to the mind immediately is that when you reclassify workers as non-exempt, we're pretty sure there's going to be a negative impact on employee morale. People go to college, they work their way up the ladder, they're no longer an hourly worker, they're a salaried worker, they don't get overtime, and now all of a sudden they're put back. They're going to see it possibly as a demotion. You're going to need to get a communication plan together and make sure that the employees do not perceive the reclassification from exempt to non-exempt as a loss of status or as a demotion. We think that's a real important thing to consider. You may want to get some consultants involved in terms of that communication plan. Employees who are reclassified as non-exempt may believe they have less promotional opportunities, something else you're going to need to deal with. And they also may lose some benefits if you don't change your benefits plan. These are all things that could negatively impact workplace morale and things you need to think about. When you're putting together your communication plan, explain to the reclassified employees that it has nothing to do about their positions or the jobs they're doing or their pay is going to change. Nothing really changes except they may actually earn overtime, that this is just the result of government regulations that have changed the way you have to pay them and it has nothing to do with their performance, and that is required by law. There are some common errors that we need to discuss that many employers have and we need to avoid. Many employers, and I can't tell you, I see this all the time, that employers assume that just because an employee is paid a salary, they're not entitled to overtime. That is absolutely not the case. Remember, getting paid a salary is only one of the tests. A second test is what is the level of the salary, and the third test is what are the job duties. Let me come back to administrative assistants as an example. They get paid a salary, and they may get paid a salary high enough under the old rules where they wouldn't get overtime, but their job duties are certainly not qualified under the job duties test for any of the qualifications and classifications that we went through before. They don't exercise independent discretion, they don't supervise. So even though a secretary or an administrative assistant gets a salary, they are not entitled to overtime. So that's the first very common mistake. Besides that, many employers improperly apply an exemption. You really need to drill down, and you do need to get some advice from people who practice in this area often, because there's a lot of decisions, there's a lot of regulations, and it's very easy to apply an exemption improperly, which can cause liability. Some employers, and I see this often, limit the number of hours employees are allowed to record. Or it's some work that happens really before the workday or after the workday is over and it's not recorded. That's off the clock work. That can lead to significant liability. You need to stop that. You need to take an audit and see which of your supervisors is engaging in that type of activities. Another common error is that employers make improper deductions from wages that cut into the required minimum wage or overtime. You need to look under state law what deductions are appropriate, what are permissible. Make sure that you're not doing something that is not lawful, because again, that could lead to significant liability. And again, something that happens all the time is there's many employees have Blackberries, iPhones, smartphones and such, and they're always texting and doing work outside of the workday, checking emails and texting and doing things like that just because the technology allows them to. That's work. That's work. Other than de minimis, real small amount of activity, they are entitled to be paid for that work. You should have policies and procedures in place that advise employees that they're not supposed to do this, and you should make that a regular part of your orientation and follow-up communications with employees, because otherwise they could be entitled to be getting pay, overtime pay, for texting and emailing after the regular work day. So that's all I have for you at this moment. The real takeaway is that you need to be aware of these new proposed regulations. You need to study your organization. You need to start planning for these new regulations. And you need to take action now so that you're ready when they're implemented in 2016. Thank you.